Yes, Mr. Rees.
My Lord, Sir James says that there's no novelty in what the appellants propose. In reality, the approval of the appellant's approach to redaction for, as they term it, irrelevance, would represent a significant dilution of public authority's duty of candour, as presently understood. Meanwhile, the appellant's alternative submission on good reasons, as they term it, would carve out a new derogation, ill-defined and unsupported by authority or principle. Either option proposed to you by the appellants would strike at the systems and norms that the duty of candour exists to protect, and I shall shortly give you reasons why. Before I do that, however, may I start with a few points about the consequences, context, and definitions that apply here. As for consequences, the logic of the appellant's submission is far-reaching indeed. They say that where a document is disclosed in judicial review pursuant to a duty of candour, central government is entitled to redact any material which will not affect the outcome of the issues. In essence, an entitlement to redact wherever a test of direct relevance is not met. Thus, the appellants say, central government can redact the names of civil servants unless the outcome of the case may turn upon identity. The appellants draw the line at redacting the names of those classified as junior civil servants. As Mr. Justice Swift noted below, Judgment 25, and as your lordships noted this morning, this category includes civil servants with significant responsibilities. And your lordship saw, of course, the reference in Cox to junior civil servants whose reports and recommendations may go to ministers and who may contribute significantly to decisions taken by senior grades and ministers.
Well, junior civil servants who have senior as part of their job title.
Yes, my lord, absolutely, absolutely. And as my Lord Justice Bean observed, and as the appellants themselves say, the logic of their position might mean that the names of decision makers themselves would be redacted. The only clear exception to their entitlement to redact that the appellants envisage is where an individual civil servant faces an allegation of bias. So the redaction of junior civil servants' names might be troubling enough, but the logic of the appellant's case goes far wider. As my Lord Justice Bean observes, it extends also to the names of senior civil servants, and the appellants rightly accept as much, both in oral submissions and at paragraph 24 of their skeleton. They say that while they're entitled to redact the names of senior civil servants, they will not do so as a matter of benevolence, or as my Lord Justice Lewis put it this morning, grace and favour. In fact, as I shall show you later, the names of some senior civil servants were redacted in this case. The same logic would, of course, also apply to the government's contractors. And again, as I shall show you later, the appellants did redact the name of some contractors, including those at senior echelons. And indeed, if we take the appellant's logic on redaction on the basis of irrelevance, as they term it, to its startling conclusion, this would also permit the redaction of the names of ministers. That is, of course, because statutory powers are at least usually conferred upon the Secretary of State as an office, not a person. So it would be a very rare case in which a Crown of Judicial Review turns upon which individual was the decision-making minister. And so in the narrow and direct sense in which the appellants use the term, the name of the minister will not be relevant, quote unquote, to the issues before the court. And presumably the appellant's answer here too would be, okay, we're entitled to do it, but we will, in practice, benevolently refrain. And in short, what the appellant's submission does is leave the government with a sweeping discretion to redact names which they do not exercise merely as a matter of grace and favour. But the limits of a duty of candour cannot, we say, be defined by the benevolence of government policy at every given point in time. So the appellant's case proves far too much. What about public servants who are not in the civil servants? Suppose that the appellant's approach to redactions of names were upheld. As Mr. Justice Swift noted at paragraph 16 below, the same reasoning would apply for all public authorities before the courts in all judicial review claims. And who exactly is to be protected? Few other public bodies outside central government use an employment structure which delineates between junior and senior grades in the same way as the civil service. So there's no simple rule that maps over. So the problem is suggestive that the appellants are approaching this incorrectly. It also runs the risk of the courts being embroiled in myriad disputes about which categories of public employees are or are not entitled to withhold their names and disclosure. Finally, still on consequences, and as Mr. Justice Swift noted below at paragraph 16, the logic of the appellant's submissions goes well beyond names. So James says that we're not arguing about content, but this court's judgment will, of course, bear on content too. If the appellants are right about retraction for what they term irrelevance, then it would permit, as Mr. Justice Swift said below, the removal of any part or word in the text of a document that did not in some way directly concern a ground of challenge. So broad an entitlement to withhold information is likely to yield an outcome of, to adapt Lord Donaldson's famous phrase, cards face upwards, but largely blacked out. And I shall come back shortly to whether that outcome is consistent with the duty of candour. So those are consequences. Turning to context, it is important to appreciate that the appellants are claiming special treatment for civil servants and have not explained why the distinction is justified. Other public servants, at least for the time being, do not routinely seem to have their names redacted as a class. And that point was recently noted in the case of Snedden. I won't ask you to turn it up, I'll give you the reference in a moment, but Mr. Justice Fordham in that case expressed complete agreement with Mr. Justice Swift's judgment here, refused a request to redact the names of junior civil servants appearing in his judgment, wondered what made civil servants so different from a prison psychiatrist or an offender manager, the issues in that case, and said of a singling out of public servants in central government protection that there is no special treatment. The reference is Authorities tab 44, page 1317, paragraph 50. I said I would also mention definitions. 2 short points. The appellant's redactions engage 2 important principles concerning the administration of justice and the rule of law, and it's important not to conflate the 2. When disclosure is withheld in judicial review by public authority from the court and opponent, the question is whether the duty of candour is discharged, and that's the focus of the respondent's submissions in this appeal. When disclosure is withheld from the world at large, that engages the question of whether any derogation from open justice is justified. And as we understand it, open justice is the focus of the intervener's case. A derogation from the duty of candour, such as the appellants propose in their fallback submission on good reasons, inevitably impinges on open justice. But of course, the converse is not true. The 2 do not always march hand in hand. The second point that we make as to definitions is that the appellants state that they're entitled to withhold junior civil servants' names because those are irrelevant. But the scope of what is relevant is contextually determined. Relevance means one thing in standard disclosure, another in specific disclosure, and has yet a third meaning in the context of a discharge of a duty of candour. It's a protean concept, and use of the term is apt to muddy the waters, as the Court of Appeal in substance observed in Shah, case I'll return to. So relevance is simply shorthand for what does the particular duty and issue require. In this appeal, as concerns the question of what should the court and respondents see, the question is simply whether the appellant's approach to redactions is consistent with their duty of candour. Or to put it another way, Sir James emphasised to you this morning that the material must be connected to the resolution of the issues in the case, understood as both pleaded and unpleaded grounds. Of course it must, but that formulation tells us nothing about the degree of connection. Sir James Eady's Submission does nothing to explain why the narrow, directly determinative relation between the material and the issues for which he contends, and which applies to standard disclosure under CPR Part 7, i.e. whether the material would result in litigious advantage or disadvantage. He says nothing about why that should apply to the duty of candour. And with that somewhat lengthy preamble, I shall turn now to the respondents' main submissions. And we have 6 headline propositions, which I'll briefly summarise if I may before developing them. First, the duty of candour of a public authority in judicial review is a duty to assist the court, both in achieving justice and fairness in a particular case, and in fulfilling more broadly the public interest in the rule of law.
If you're going to give us 6 headline propositions, and certainly if you want me to write them down, you'll have to go more slowly.
I am so sorry, Madam.
All right.
Absolutely, I'm grateful for the indication. So first, the duty of candour of a public authority in judicial review is a duty to assist the court, both in achieving justice and fairness in a particular case, and more broadly in fulfilling the public interest in the rule of law. Second proposition, it's antithetical to the candour duty to make redactions which obscure context, significance, or intelligibility, or which apply an approach of redaction by default. Third, we say that the problems associated with the appellant's general practice of redactions are exemplified by their redactions in this case. Fourth headline proposition. On a proper analysis, the appellant's approach to redaction is unsupported by authorities concerning disclosure in judicial review. Fifth headline proposition, principles from the fundamentally distinct context of standard disclosure in civil litigation, now governed by Part 7 CPR, do not assist the appellants either. So parenthetically, that addresses Sir James's submission this morning that there was no earthly reason why the same test should not apply. Sixth headline submission, the appellant's fallback submissions neither identify nor pursue any legally viable derogation from the duty of candour. And I shall turn now to the first headline proposition, which concerns the sui generis nature and purposes of a public authority's duty of candour in judicial review. And could I start, please, with quark fishing, which is at tab 9 of the authorities. And could I ask you to turn up page, it starts at page 300, but could I ask you actually to go to 321, which is Lord Justice Law's celebrated formulation at paragraph 50.
Yes.
So the points I would draw out in that paragraph, it is a very high duty. It is a duty to assist the court. The duty requires comprehensive explanation. So there's the reference to full and accurate explanations of all the facts relevant to the issues the court must decide. I shall come back in a moment to that use of the word relevant. And then the real question is whether the evidence put forward has given a true and comprehensive account of the way in which the relevant decisions in the case were arrived at. And in the same vein, could I also draw your Lordship's attention to paragraph 51, a fair and full picture of a decision-making process. Going back to paragraph 50, it's a proactive duty. If the court has had to tease the truth out of late discovery, it may be appropriate to draw adverse inferences. Requires frankness and clarity. At paragraph 52, those were found to have been lacking. Before I leave Quark, could I address you, please, on the use here of the word relevance in paragraph 50? As the court saw this morning when taken to the case of Shah, relevance is often used judicially, perfectly understandably, as shorthand for what the particular duty necessitates. And Lord Justice Lords makes clear that the real question is whether, in the evidence put forward on his behalf, the Secretary of State has given a true and comprehensive account of the way in which the relevant decisions, that is, the targets of the claim, were arrived at. And that is the scope of a duty that conditions whether facts are relevant. And it means, we say, that facts and evidence are relevant for the duty of candour, even if they go to unpleaded issues, or if they go to permitting full and accurate understanding of the facts in circumstances, and that is particularly the case where evidence will very rarely be tested or explored in cross-examination. So it's a fundamental differentiating feature of judicial review that cross-examination is exceptional. Understanding the documents has particular importance. And that is also the analysis of what relevance means here that's provided by Mr. Justice Fordham in a recent case. Could I ask you to turn it up, please? It's at tab 42 of authorities. This is the police superintendent's case. And the key passage for this purpose is at page 1272. Paragraph 15, subparagraph 5. And by way of reassurance, we don't invite agreement with all the detailed summaries set out at paragraph 15, just this particular subparagraph, which usefully encapsulates precisely the point we make, which is the multifaceted meaning of relevance in the context of a duty of candour.
Which subparagraph?
I'm so sorry. 15.5. So if you're on page
Oh, yes,
1272, it's 3 up from the bottom.
Thank you.
At the heading Relevant Material Principle. Just that one subparagraph upon which we rely here. And could I ask your lordships now, please, to turn to Downs, which is at tab 11 of authorities. And the particular passage on which I want to focus starts at page 364, paragraph 21.
Can I just read paragraph 1 to find out what the case is about?
My Lord, if I can try and summarise, it was a challenge to the process by which the interim victims commissioner had been appointed in Northern Ireland.
And then the paragraph you wanted?
Paragraph 21, my Lord. So this is where Mr. Justice Girvan, as he then was, gives an explanation of the reasons for the existence of a duty of candour. Paragraph 21, page 364 of the authorities. So Mr. Justice Girvan refers to the serious disadvantage faced by individual claimants. He cites Huddleston, the executive hold the cards. So it's a duty that serves to mitigate the severe disadvantage at which claimants otherwise find themselves when challenging the state. And parenthetically, one might add to the point made there that the executive will almost invariably know the facts which a citizen does not. One might add the ordinary approach in judicial review, that witness statements made by the executive are presumed to be accurate, and the ordinary lack of cross-examination in judicial review to probe those assertions. And Mr. Justice Girvan explains that if the executive were free to cover up, redact, or withhold material or present it in a partial or partisan way, the citizen's proper recourse to the court and his right to a fair hearing would be frustrated. So the duty of candour is also concerned with access to justice and fairness. He then goes on, such a practice would engender cynicism and lack of trust in the organs of the state and be deeply damaging of a democratic process, based as it is upon the trust between government and the government. So compliance with the duty of candour is also necessary to maintain the confidence of citizens in the decisions of the state and in the administration of justice. And that is the answer to the question of why appearances matter, which Sir James criticised robustly this morning. Then over the page, and this is now Authorities 365, after quoting from Quark Fishing, Mr. Justice Girvan says that a breach of a duty of candour and the failure by the executive to give a true and comprehensive account strikes at the heart of a central tenet of public law, that the court, as the guardian of legal rights, should be able to rely on the integrity of the executive arm of government to accurately, fairly, and dispassionately explain its decision and actions. So the duty of candour is also integral to the relationship of trust between the court and the executive. And could I ask you then to turn on to page 370, paragraph 30, in the same vein, warning that breaches of a duty of candour break the trust of the court with the consequence that adverse inferences may be drawn. Then paragraph 31, public bodies and central government agencies in particular involved in the provision of fair and just public administration must present their cases dispassionately in the public interest. Justice lies at the heart of the public interest, can only be served by openness in assisting the court to arrive at a proper and just decision. And he then goes on, the judicial restraints on matters such as discovery and cross-examination would not long survive if a lack of frankness and openness were to become commonplace. And then, for completeness, lest your lordship wonder about the outcome, that appears at paragraph 60. The court found that there had been a breach of the duty of candour. Could I take your lordships next, please, to tab 28, Poirot. Just for reference, paragraphs 9 and 13, Lord Justice Singh highlights that disclosure is not, of course, automatic in judicial review, and that one reason for that lack of automatic disclosure is the separate, very important duty of candour. Turning then to paragraph 16, so I'm now on page 824, citing Huddleston, we see the reference to a new relationship between the courts and those who derive authority from public law, one of a partnership based on a common aim, namely the maintenance of the higher standards of public administration. Paragraph 17, citing Lord Walker in the Belize Alliance case, judicial review should not be conducted in the same manner as hard-fought commercial litigation. And then noting that the principles summarised by Lord Kerr and Van Koo are uncontroversial. Those principles, of course, include the application of a duty of candour to as yet unpleaded grounds. Paragraph 18, self-policing duty. Paragraph 19 and 20, as Sir James already pointed out this morning, the duty of candour is not discharged by an overwhelming dump of documents. Paragraph 20, duty of candour and cooperation is to assist the court with full and accurate explanations of all the facts relevant to the issues that the court must decide. Paragraph 20, function of the public authority itself to draw attention to relevant matters. And then paragraph 20 also, again, a reference to the common enterprise of the court and the public authority to fulfill the public interest in the rule of law. Paragraph 23, citing the Khan judgment, the duty of candour may be breached by a failure to identify the significance of a fact or document. Paragraph 24, the best evidence rule applies. Where a document is significant, it is ordinarily good practice to exhibit it. And without asking you to turn it up, but giving you just the reference, Haro is, of course, imported to a judgment of this court in Citizens UK. The reference is tab 29, and it's page 840. Drawing all those principles together, the duty of candour is a high and vitally important duty of frankness and cooperation owed by public authorities, in particular central government, and it's a duty owed foremost to the court, although also to other parties. And the function of the duty of candour is manifold. If we proceed from the granular level to high level, 5 functions of a duty of candour emerge from the authorities that I've just shown you. Compliance with the duty of candour assists the court in the immediate task before it. Next, the duty of candour is an important underpinning of judicial trust in the executive, and consequently also of the streamlined procedures in judicial review. So recall Mr. Justice Girvan's warning in Downs that judicial restraint on discovery and cross-examination would not long survive otherwise. Next, the duty of candour also ensures fairness and access to justice for claimants in circumstances where the public authority holds the card and where the public authority's account of the facts in a witness statement would ordinarily be accepted and there is usually no cross-examination. Next, the duty of candour ultimately assists the court in the common enterprise of the maintenance of highest standards of public administration and to fulfil the public interest in the rule of law. That's Downs, Huddleston, Haro. And the duty of candour, finally, serves to maintain the confidence of litigants and, in the ordinary circumstances where they are given access to the proceedings, the general public, in fair and just public administration and also in the proper administration of justice. And as Downs shows, that confidence by the ruled in government and in the courts is fundamental to the rule of law and indeed the preservation of democracy. As to the content of the duty, as we saw from Quark, a true and comprehensive account of the way in which the relevant decisions were arrived at, to it also a duty to draw attention to the significance of ostensibly neutral facts, not limited to the issues pleaded, but also to disclosure that may give rise to fresh grounds of challenge. And as for procedure, we've seen that the duty of candour is proactive, self-policing. It's not dependent on a request, application, or order for disclosure. And indeed, the existence of that duty, along with, of course, the fact that most claims for judicial review do not turn on facts, but the existence of that duty is one key reason why standard disclosure is unavailable in judicial review. And against that background, I turn to our second proposition, which is that when a public authority discloses documents to discharge its duty of candour, it's inimical to that duty to make redactions which obscure context, significance, or intelligibility, or to take an approach of redaction by default.
So before you get to your second proposition, where you really departed seems from Sir James. He says relevance is only by reference to the issues. Read just the first sentence of Quark and Huddleston, and you say no, it goes beyond that. It's the facts and reasoning relevant to the decision, and an explanation of the way in which the decision-making process unfolded. And relevance, you say, must include that second part.
Yes. I mean, my lord, but perhaps it's a quibble. We would actually say those form part of the issues, but it's really about the question of a degree of connection that's required.
It's either part of the issue or it's a separate thing that comes within it.
Yes.
Yeah. But it can't be excluded.
Yes. And the point I'm making essentially is that the appellant's formulation of relevance is what we call direct relevance. That is the concept with which we're all familiar from standard disclosure in Part 7 cases. Does the case turn upon it? Does this material generate a litigious advantage or disadvantage? But the duty of candour goes well beyond that. And so it's the true and comprehensive account, the understanding of the process by which a decision was reached. But it is also, and that's the point I'm about to come on to, an appreciation of significance of particular documents or incidents, and intelligibility, and then the question of public confidence. We say those all condition the scope of the duty of candour. But still, absolutely, it is about the issues in the case. Another way of putting it is that the duty of candour is proactive. It doesn't depend on what do the individual claimants know. So you need to give them material that they may not understand is significant, material that may give rise to unpleaded grounds. The material may itself expand the issues. On the question of significance, why is the question of not obscuring significance part of a duty of candour? The duty of candour, unlike requirements of standard disclosure, requires a public authority to draw attention to the significance of ostensibly neutral information. And we say that the redaction of names is liable to have the opposite effect. And Mr. Justice Swift has twice commented on that, in fact. The first time, I won't ask you to turn it up, but the reference is FMA, and it's an authorities tab 41, page 1264, paragraph 48. The second time he commented on it, of course, was in the judgment below, and that's paragraph 18 of the judgment. So how is the redaction of names liable to impair the appreciation of significance of a text around it? To name just a few hypothetical scenarios, suppose comments are made in an email or in margin comments stating that the decision or policy is misconceived. The significance of those comments is likely to depend in some part on the expertise of the individual making the comment. And as we've already seen, of course, junior civil servants include people in significant positions of responsibility. Or suppose that civil service advice or recommendations are sent to a minister explaining the rationale behind a decision or policy under contemplation. Again, the significance, the weight to be given to those explanations may depend upon the identity and expertise of the individual making the comment. Or suppose someone contradicts themselves. What they say in one document is undermined by what they say in another. Impossible to know with identity redacted. Or suppose key information that ought to have fed into a decision was in fact not passed on. One set of junior civil servants collects information which then does not make its way to the junior civil servants advising the minister. Difficult, if not impossible, to discern with the recipients of email chains redacted. Or suppose that someone comments on a document who was not entitled to do so, or whose involvement colours the weight to be given to a document itself. Or examples of the way in which the redaction of names impacts upon significance. What about intelligibility? A key function of disclosure provided under the duty of candour is to enable the court and the opponent to trace and understand the development of a policy or decision. So the court is likely to have to look at long email chains branching off into different directions. And they may have to trace those across different batches of disclosure, as happened in this case. So just before Mr. Justice Swift, there were 3 batches of disclosure, 4 bundles, further disclosure received afterwards, all had to be somehow pieced together. And of course, documents may emanate from or traverse different departments. And tellingly, the appellants do accept that sometimes there has to be a way of seeing who has drafted or commented upon which document. And they say that these problems can be addressed by ciphering or by supplying lists of titles and job descriptions. That was Sir James's submission this morning, and it's also their paragraph, appellant's paragraph 18. And we do say with respect that Mr. Justice Swift is entirely right to note at paragraph 19 below, but this approach would be, and I quote, laborious, prone to error, and even when error-free would add a new layer of complexity to the task of understanding the narrative of a decision-making process from the documents disclosed. And of course, as Lord Justice Bean noted this morning, the potential is inundation of the administrative courts with interlocutory applications for ciphering to take place or for ciphering to be sorted out where it has gone wrong. Still more fundamentally, the duty of candour is one of cooperation, assistance, frankness, and openness. If a public authority unnecessarily impedes understanding of its own decision-making process, that's inimical to the duty. And again, we say, therefore, Mr. Justice Swift was right at paragraph 20 below to say, an approach of compliance with the duty of candour that as a matter of routine hides detail that aids the court's understanding of the public authority's explanation is antithetical to the duty of candour. I turn now to the issue of confidence. And we do say that it's clear in particular from the analysis in Downs that the duty of candour has among its purposes those of maintaining public confidence in good administration and in the proper administration of justice. And the appellants claim to be able to redact swathes of information, not on the basis that they have a legal duty or right to redact, but rather on the basis that disclosure is unnecessary. And that is effectively redaction by default. It's a practice of redact when we can and because we can. And that approach to redaction in reality undermines the administration of justice. Now, we've put on your desks, and I don't ask you to look at it now, the case of XY, which we sent to all the other parties last night. I'll just briefly mention which are the key paragraphs rather than taking you to them. I would respectfully suggest that a glance at paragraphs 123, 135, and 136 exemplify quite how seriously wrong an excessively broad approach to redaction can go.
123.
So I beg your pardon. 123, 135, and 136. Now, this is not a case about redaction of names. In fact, rather puzzlingly, given the defendant's position as to the necessity for such redactions, we can see from paragraph 130 of the judgment, there was no redaction of names. So the redaction there is content. The reason I refer to it came out yesterday. It's a recent consideration of how Mr. Justice Swift's judgment should be applied. And it also bears on a point that was raised for the first time in this appeal by Sir James this morning. Sir James raised the question of procedure and complained that witness statements explaining the reasons for redaction were unnecessarily burdensome. And in fact, this case shows how important witness statements can be. What the chronology appears to have been in this case is that there were extensive redactions of content. Mr. Justice Swift's judgment below then came out. That prompted a witness statement from the Secretary of State's lawyers in that case and a review of their redactions. leading to passages being disclosed, which, as the court said, could not properly, on any view of a duty of candour, have been redacted. In other words, the witness statement served a vital function of concentrating minds. My lords, that's all I will say about XY. So a careful approach to redaction enforced, as it were, by witness statements is vital. But we also say that it's antithetical to the purpose and tenor of a duty of candour to have even an appearance of secrecy or of obstruction on the part of public authorities in judicial review. And the proposition that the routine redaction of information disclosed under the candour duty will undermine public confidence, which it can be tested in this way. The appellants say that even the names of decision makers can be redacted, albeit, they say, replaced by ciphers if there's good reason for ciphering. And of course, it's true that the name of a decision maker will in most cases make no difference to the outcome. But such redactions, for example of the names of decision makers, will risk significantly impairing confidence on the part of individual litigants and by the general public, but the government is accountable to those affected by its decisions, or that the courts can properly, fairly, and impartially administer justice. So we say Mr. Justice Swift was entirely right to say, at paragraph 20 below, that the approach to redaction for which the appellants contend risks undermining confidence that appropriate legal scrutiny is taking place under fair conditions. And no doubt that is part of the reason why the Treasury Solicitor's guidance on the discharge of a duty of candour that the court looked at this morning takes such a cautious approach to redaction. The advice there is do not redact if you can disclose. The appellant's approach now would reverse that. It becomes an approach of redact when and because we can. Turn now to our third proposition, which is that the problems just described are exemplified by the approach to redaction taken in the present case. And your lordships should have a table on your desks, all the parties also have it. And just by way of background, before going into the detail on this table, the underlying claim here involves, as well as a challenge to the vires of the draft regulations in question, a proportionality question under Article 14, read with Articles 2 and 3 ECHR. And the underlying claim also challenges the decision-making history and processes underpinning both the draft regulations and the first appellant's policy, for example, compliance with a Thameside duty and with a public sector equality duty. Just to give you the reference, if you want to know where to see the grounds of challenge, the grounds are in full at core bundle, page 164 to 201. I'm not asking you to turn those up, but the index at page 164 to 165 suffices to give an overview of the grounds. And the claimants now have permission on the grounds listed there, save for the abdication point that they did not pursue. So it is a case that, because it involves proportionality and because it involves a challenge to the procedure by which decisions and policies were made, does involve more intensive factual scrutiny. So just the reference, of course, is, for example, Lord Bingham in Tweed at paragraph 3, Lord Brown, Tweed, paragraph 54, referring to the more intensive factual scrutiny in such claims. However, we are the first to say that this is not a claim that turns in particular on names. Doesn't, for example, concern bias. As Mr. Justice Swift noted at paragraph 17 of a judgment below, the respondents have never suggested that the disclosure of names will affect the outcome of their claims. But that is, of course, for all the reasons I've given, not the test. The respondents, for that reason, made no application for specific disclosure of names. They made only cautious and very targeted requests for the specific disclosure of certain passages relating to content. And that's the second part of Mr. Justice Swift's judgment below, which is not under challenge. So with that preamble, if you could look at the table that I've just given you, there are 4 points that I would highlight about the redactions in this case. First, in an illustration of what one might term redaction creep in relation to names, while the appellants seek only in this appeal to defend their redaction of junior civil servants' names, they have in fact redacted, in some instances, the names of senior civil servants. They've also redacted the names of their private contractors. Second, illustrating the sorts of errors and inconsistencies to which a sweeping practice of redaction is liable to give rise. The appellants say at footnote 6 of their skeleton they have not redacted the name of the Home Office's Tahira Shah, even though she's a junior civil servant, because of her importance to the claim. And indeed, she has given witness evidence in the underlying claim, and she is named in the draft explanatory memorandum. But nonetheless, her name was, in certain documents, redacted. And I should say, of course, we now have, on the respondents team, a far greater understanding of what's happened, because we have in the confidentiality ring, as Sir James explained this morning, the unredacted copies of the documents. We've been able to match those up. The third point I would highlight here, illustrating Mr. Justice Swift's point at paragraph 25 below, that junior civil servants may in fact have significant responsibilities. For example, the name of a second appellant's head of standards in the private sector is redacted. So too, and this was a point made by my Lord Justice Mayles, that even those who are senior in their title are deemed to be junior civil servants. The senior private secretary to the second appellant has had their name redacted. Four, there are redactions that obscure the provenance of important documents. And moreover, of course, the examples that are given in this table need to be read in the context that these documents had to be understood against hundreds of other pages of redacted disclosure. And the cumulative effect on intelligibility is not insignificant. And I shall take you just to 2 examples of that, if I may. The first is page 223 to 226, supplementary bundle. And mindful of time, I shall go quite fast. This is an email chain dated the 29th of November 22 to the 6th of December. And if you start at page 226, you'll see that there's discussion of a joint note, and you see that, as I already mentioned, the head of standards, private rented sector, has his or her name redacted. And then if you turn to 223, we see that the submission is sent to the private secretary of a second appellant, but we cannot see the name or department of the sender of the submission. If you now please turn to 227, this is the ministerial submission in question, and it's an important document explaining the development of the first appellant's policy and the second appellant's draft regulations. But if you look at the top right of page 227, we can't see the provenance, the authorship of the document. We cannot tell their name, their title, or even their department. The fifth point that I would make by reference to this table, prepared, I should say, by my excellent learned junior, Miss Irving, which I'm very grateful. The fifth point is that as I already mentioned, the guidance given by the court in this appeal will not only affect the approach to redaction of name, but also redactions for content. And there are two examples that I shall mention quickly of such redactions. And the risks inherent in a lax approach to redaction. If you look at page 219 to 220, this is a letter dated the 10th of November 22 from the second appellant personally to the Prime Minister. And this is one of the two passages for which the respondent sought specific disclosure from Mr. Justice Swift below and were granted it. And we sought disclosure in carefully limited terms only of the redacted passage running from the last page at the bottom of 219 over to the end of the first paragraph of page 220. And if you look then at 319, if you look forward please at 319, this is the passage he redacted. So the redacted text read, from the second appellant personally, referring to the draft regulations under challenge, I am strongly opposed to it. And then, more importantly, later on in that paragraph at 320, this move undercuts our broader position that accommodation is safe irrespective of who is housed. And then the next redacted sentence reads, I cannot support an attempt to remove HMO licensing, but have asked officials to explore the issue further with colleagues. Now, that was de-redacted pursuant to the order of Mr. Justice, but it illustrates the dangers of liberal redaction being used for the impermissible reason of, in essence, avoiding political embarrassment.
Just out of curiosity, did they explain at the hearing below what the basis of the redaction was?
My Lord, we've actually got, I hope, in the bundle, and I'm sure my juniors will help me with this, a note in which they sought to explain it in the bundles, and I'm just, I may need to come back.
Don't worry.
I apologize. But in essence, the answer was that this was the personal political opinions of a second appellant and irrelevant because we knew the final decision and therefore nothing turned on this. So in a sense, this is where the narrow view of relevance risks ending up. The notion that essentially it's a return to terminus theory. You've got the final document, so what does it matter that you don't know how you got there?
It looks as if the explanation may be 266, is that right?
I'm very grateful for that.
It may not be.
So that was so at 266. My Lord, this is a rather convoluted explanation I'm going to give you. That was a key that was given to us initially, which notably missed out entirely this document. And I have now been given by my excellent learned junior, Mr. Knight, the note that I referred to that was handed to Mr. Justice Swift by the appellants below. It's at page 301, supplementary bundle, and it's paragraph 11. And the explanation was the redactions in this document are political views expressed personally by the Secretary of State. Such views are generally irrelevant to a decision under challenge. Once a decision to pursue the policy was taken, and bearing in mind that draft regulations were laid by the junior minister with agreement from the second defendant personally, it's plain that the second defendant considered the draft regulations appropriate. So in essence, you know the end point, you don't need to know how he got there.
And again, sorry, just for my own information, really, I suppose I could find out. It is a junior minister, but a junior minister in which department? Levelling up?
Levelling up. It's Miss Felicity Buchan, yes.
If you're on the explanation, you might read it 12 and 13 as well.
My Lord, still on the question of redaction of content, I'm sorry, you're perhaps still looking at the passage to which Sir James has drawn your attention. Still on redaction of content, could I draw your attention to supplementary bundle 272 to 282? And I'm showing you this as an example of extensive unexplained redaction, which makes it difficult, if not impossible, for individual litigants and judicial review to determine whether material is or is not required under the duty of candour, and makes targeted requests for specific disclosure very difficult. The redactions are so extensive that gleaning what these passages are about is often simply impossible. And this is one reason why we do say that the appellant's attempt to essentially assimilate the test for the duty of candour with the test for specific disclosure doesn't work. The specific disclosure test arises against a context where it's assumed that the duty of candour has been discharged. But how were we, for example, as claimants below, to know what to seek in specific disclosure without embarking on an impermissible fishing expedition? And we do also say that this sort of extensive redaction illustrates the sorts of suspicions that are liable to be created by unnecessary redactions in the minds of a court and the general public. I don't ask you to turn up all of them, but the de-redacted passages are at 356 to 366. And suffice to say that some of it was plainly required under the duty of candour, in particular at 356 to 357. So, in summary, the concerns of Mr. Justice Swift that the redaction of names impairs the appreciation of significance, impairs an understanding, and more generally, that a liberal approach to redaction is antithetical to frankness, cooperation, and liable to undermine confidence in the administration of justice. All those concerns are applicable here. Our fourth headline point is that the judicial review authorities, properly understood, do not support the appellant's case on redaction for irrelevance. And if I could ask you to turn back now, please, to the authorities. This is Tweed at tab 12. And reiterating the point I made earlier, this is the determination of an application for specific disclosure. The duty of candour had already been complied with, and there was no suggestion that there had been any deficiency in discharging the duty in that case. And that's particularly clear from paragraph 39, Lord Carswell's judgment. This is pages 404 to 405. If I could just ask you to look at paragraph 39. That's the essential context. And then if your lordships turn back, please, to the earlier part of a judgment and paragraph 3, this is, I'm now at page 390 of the authorities bundle. Lord Bingham says that the test for specific disclosure is whether in the given case disclosure appears necessary in order to resolve the matter fairly and justly. At paragraph 4, he explains the best evidence rule. Ordinarily best practice to exhibit a document that's relied upon as significance, no need to suggest incompleteness or inaccuracy in the summary provided. It's enough that the document itself is best evidence of what it says. Now, the 5 documents in question had been withheld by the Parades Commission because they were said to contain information imparted in confidence, as to which a legal duty of confidence was said to be owed. And that can be seen of paragraph 5, Lord Bingham. And I'll come back to it later, but it also appears particularly clearly at paragraph 57 of Lord Brown, where he explains that but for the important matter of confidentiality, it seems to me almost inevitable that they would have been exhibited, the documents would have been exhibited. Now, the unanimous conclusion of their lordships was that if material was confidential, this was not of itself sufficient basis to refuse disclosure of information necessary for the fair and just resolution of the case, but that confidentiality was a relevant factor in determining whether information required to be disclosed. And in so holding, they were applying nasse. I don't ask your lordships to turn it up. I'm just going to give you the reference. It's Authorities tab 4. Nasse is, of course, the leading authority holding that confidentiality alone is not sufficient basis on which to withhold disclosure. And the ratio of nasse can be seen from Lord Wilberforce at page 200 of the Authorities bundle. But staying in Tweed, could I ask you please to read paragraph 5 of Lord Bingham's judgment in full? Lord Bingham says that if there's no confidential information from informants, the documents are likely simply to be disclosed since there will be no reason not to do so. On no proper reading is Lord Bingham approving redaction if there is not confidential material. And it's also clear from the later judgments that where redaction is discussed in this case, the issue is whether it's necessary and permissible to redact for confidentiality, applying the principles in nasse. And I would emphasize that both Lord Carswell, and this is paragraph 37, and then Lord Brown, paragraph 58, expressly state that they are following nasse. So what their lordships do is essentially envisage a flowchart. If the document, which should be reviewed, they say, by the judge to whom the case should be remitted, if the document does not meet the test for specific disclosure, then there's no need to redact, the document need not be supplied. If the document does meet the test for specific disclosure, then the court will consider whether redaction of the confidential parts is permissible and required. That is, their lordships are talking in Tweed about redaction of confidential information only. And then they say, if the confidential passages themselves meet the test for specific disclosure, the judge will need to proceed to consider any application for public interest immunity. That's what Lord Bingham is saying at paragraph 5. Likewise, Lord Carswell at paragraph 41 and Lord Brown at paragraph 58.
They're not talking about duty of candour and non-confidential information. And what they're saying is, if you might satisfy the test for specific disclosure, but there are ways of balancing the harm of specific disclosure if properly used versus the need for the claimants to have access to it. That's when they might do it. So it's a lesser way of damaging the public interest when you grant specific disclosure, like confidentiality ring, rather than not doing it at all.
Yes, I mean, I think I would stress that they are applying nasse, and therefore it's very clear that they're saying if the document requires specific disclosure and the specific confidential passage requires specific disclosure, it will have to be disclosed unless public interest immunity is sought and granted. My Lord, perhaps I can just make the point simply in this way. Tweed does not assist the appellants for the propositions that the appellants advanced for 2 reasons. First, the discussion of redaction in Tweed is not about redaction for irrelevance at all. it's about redaction for confidentiality. And second, Tweed is, of course, a case about specific disclosure. And the applications for specific disclosure in Tweed, as we saw, were being considered against a backdrop where the public authority had already discharged its duty of candour. Turning on now to another case that the appellants assert makes their point. This is the case of a National Federation of Self-Employed. I won't ask you to turn it up, the submission is short. Just for reference, this is tab 5 of the authorities and the dicta of Lord Scarman, on which the appellants place great reliance here at page 263. Again, the National Federation of Self-Employed is not about the duty of candour at all. It predates Huddleston, which is generally viewed as the start of the understanding of a duty of candour in judicial review. And the passage to which the appellants point is about specific disclosure, and moreover, taking a narrower approach to specific disclosure than that applied in the modern cases post-Tweed. Really, what Lord Scarman is saying in the passage to which the appellants point is simply that fishing expeditions are impermissible. And that's clear also from the comments of Lord Roskill in the same case at page 273, penultimate paragraph. So the only judgments concerning disclosure in judicial review, which even ostensibly support the redaction of names, are the two judgments in the Good Law Project litigation. But on proper analysis, they have limited assistance at best to the appellant's case as well. And your lordships have already looked at those cases in some detail. I won't ask you to turn to the Good Law Project first judgment again. Suffice to say that at paragraphs 23 to 27, the discussion is whether names should be, quote unquote, made public. For example, last line of paragraph 27. As we already saw this morning, the parties had entered into a confidentiality ring, which included not only the lawyers, but 6 representatives of the claimants in that case. So, although the judge considered that she was applying the principles in Shah, she was in reality looking at what should be disclosed to the public, not what should be disclosed to the individual litigants or the court. And that's particularly clear from paragraph 28 of Good Law Project 1, where Mrs. Justice O'Farrell says the starting point of the court is to consider whether the names of the individuals in respect of which it is sought to put into the public domain are relevant. And that elision between the duty of candour and its requirements and then considerations over open justice continues at Good Law Project 2. And the key issue in that case was that the claimants had referred to documents disclosed to them in the confidentiality ring in their skeleton argument. They wanted to release that skeleton argument publicly in unredacted form. And Mrs. Justice Farrell again considered the Shah judgment and purported to follow it. But yet again, the two issues of candour and open justice were elided. There's no indication that Mrs. Justice O'Farrell considered the issues of whether redacted names impaired the appreciation of context significance or impaired intelligibility of those documents. And she didn't need to, of course, because the documents had already been released into a confidentiality ring. So at least the claimants' lawyers and representatives were working from the unredacted documents. And as my Lord Justice Lewis observed, it's unclear why candour was considered to be an issue in Good Law Project at all, in circumstances where the claimants' lawyers and at least some of the claimants' representatives had seen the contested material. It's also not clear from the judgment, I should say, whether or not the judge had seen the unredacted skeleton. We've tried to work it out and we can't see it on the face of a judgment. But it is clear that the way in which the matter was approached by the claimant's experienced barrister, Mr. Jason Coppell, was that it was a case about open justice, paragraphs 230 and 231.
there's not, on the face of it, much point in giving a judge a redacted skeleton.
Quite, yes. I obviously don't want to speculate, but one would think so. So we do say the Good Law Project cases offered the most limited assistance to the appellant. I turn now to our fifth headline proposition, namely that cases concerning civil litigation now governed by Part 7 do not assist in determining the requirements of a duty of candour in judicial review. And could I ask you please to turn back to Shah, which is at tab 18, authorities. Shah is not, of course, authority for the appellant's proposition that they're entitled to redact name in disclosure provided under the duty of candour in judicial review. The case is not about judicial review or the duty of candour. It's about standard disclosure under Part 7. And as we already saw, standard disclosure is ordinarily unavailable in judicial review in significant part because of the assumption that public authorities will have complied with their duty of candour. And of course, the Shah judgment itself, in the passages you looked at this morning, makes clear that the test for redaction is not relevance or irrelevance, even under Part 7. Relevance is simply shorthand for what does the relevant rule reply. So the passages which I would highlight, you saw paragraphs 23 and 25 already, referring to the dangers of using the word relevance. At paragraph 32, Lord Justice Lewison replicates the 4 categories of documents described by Lord Wolfe in his Access to Justice report. And of course, the documents requiring disclosure under standard disclosure are only those falling within Roman numeral 1 and 2. That is, only those documents which would, if disclosed, occasion litigious advantage or disadvantage. If we look then at paragraph 37 of Shah, we see that the answer in Shah relates strictly to the pleaded issues. All of the positive ways in which the claimants sought to advance their case in Shah had already been rejected, so there was no case put forward by the claimants which the redacted information might support. And then paragraph 37, we see that train of inquiry material was not required. Paragraph 42, further emphasis on the pleaded case. And then paragraphs 49 to 50 we see obiter dicta, Lord Justice Lewison saying that redaction was permissible because the names could at most give rise to a train of inquiry, which is not part of the more stringent CPR test. So names may need to be de-redacted on a somewhat more generous test than that presently applied to standard disclosure with CPR.
This was a case in which Mr. Justice Coulson had directed that the individual should be identified by function, though not by name. Paragraph 8.
My lord. Yes. Yes.
So the claimants are allowed to know that it was the head of whatever who had done it. But Lord Justice Lewison said their request for the names was a fishing expedition.
Yes, precisely. And he also says, obiter dicta, at best, train of inquiry, you essentially saying you might just about have scraped home under Peruvian guano. But this makes our point that the definition of what is, to use the appellant's term, relevant, makes all the difference. There is not a single monumental definition of relevance that crosses all contexts.
Well, there's also the context. This was a claim where the bank refused to pay money that the customer instructed them to pay.
Yes.
And the bank said, we're breaching your instruction because we suspect that you're money laundering. And when the company said, well, who says we're money laundering? The bank said the only persons whose suspicion we are going to rely on is Mr. Wrigley.
Yes.
And that was it. But you would submit, I suppose, that the context in a public judicial review is quite different from that. It's not saying the government can decide who will we say has got the suspicion. They're supposed to be, you will say, I imagine, explaining to the court how the decision-making process actually went, not selecting which ones they want to rely on.
And my Lord, yes, and there's a further point of distinction, which is paragraph 63. If you look at Lord Justice Hill, who, like Lord Justice Mumby, agreed with Lord Justice Lewison, he adds a further point. He said that claimants would have the opportunity to cross-examine uphill and down dale any witness called by the bank to make good their point. So it's a further point of distinction that there would be the opportunity to cross-examine Mr. Wrigley about, well, what really was your basis of suspicion of money laundering? Not so ordinarily in judicial review. So the documents have a different significance, an enhanced significance in judicial review for that reason. So 4 important points of distinction between Shah and the present case. Shah concerns an entirely distinct disclosure duty. The duties of openness, frankness, cooperation with the court, facilitation of understanding and appreciation of significance, considerations of public confidence did not apply. Next, the categories of information and documents which required to be disclosed under the duty in question, standard disclosure, were entirely distinct. Next, Lord Justice Lewison recognised obiter dicta that had a different, somewhat wider approach applied. Names might just about have had to be disclosed. And finally, the claimants in that case would be entitled to cross-examine.
Because if the context had been different, and if it had been a government department that had refused to make a payment under a guarantee, you'd expect the government to say, well, the reason why we didn't was these 3 people all told us that you were a dodgy customer. And if the government said, we're going to tell you one of the people said you're a dodgy customer, but not the other 2, that would rarely apply in judicial review. It's almost inconceivable that the government wouldn't say, in fact, we acted for 3 sources of information rather than 1.
And but we're only going to tell you about 1. I mean,
Yeah.
and of course, one of the reasons why that wouldn't happen in judicial review is, of course, the risk of adverse inferences. Our 6th headline proposition, our last one, is that the appellants have no legally coherent or evidentially based fallback submission. So, for all the reasons already given, Mr. Justice Swift was, we say, right to hold that the appellant's approach to redaction for so-called irrelevance generally and for the names of junior civil servants specifically, on which the appellants might be able to redact. Can they, if there is a duty of candour requiring the disclosure of these names, derogate? Below, the appellants advance an alternative submission that if JCS names, if junior civil servants' names are broadly relevant, but only peripherally so, it would be proportionate to redact on the names that junior civil servants had a general expectation of confidentiality. That can be seen, for example, at paragraph 24 of the judgment below, and also paragraphs 23 to 25 of the appellant's skeleton below. But the appellant's fallback submission has quietly now been reframed as a case for a reasonable expectation of privacy, paragraph 4 of the appellant's skeleton, 40, I beg your pardon, of the appellant's skeleton before this court. So, in our submission, where information does require to be disclosed under the duty of candour, then that information can only be withheld where there is a legal right or duty to withhold it. That's the language that applies to withholding disclosure in the context of standard disclosure in CPR Rule 31.10, subparagraph 4a. And perhaps a point of interest, it's also, we note, the language used in the Treasury Solicitor's Candour Guidance, reference Supplementary Bundle 79, the bases on which disclosure of information otherwise required under the candour duty could be withheld. Now, the recognised categories are public interest, immunity, legal professional privilege, or statutory exceptions, but we entirely recognise that those categories may not be closed. There may be other legal rights and duties that require redaction. For example, if there would be a breach of the ECHR. occasioned by disclosure. But the appellants point to no legal right or duty to redact. Whether framed as a reasonable expectation of confidentiality as below, or privacy as here, the appellant's fallback submissions identify no recognised or viable legal basis on which to justify redactions of information otherwise required by the by the duty of candour. Their submissions are simply legally incoherent. As concerns confidentiality, there is of course a difference between, on the one hand, a mere expectation of confidentiality, and on the other, information which, owing to its very nature and the circumstances in which it's imparted, is subject to a legal obligation of confidentiality. A legal obligation of confidentiality is a narrower and more stringent test, and that is what was being discussed in Nassay and then in Tweed. And it's also what Mr. Justice Swift envisages when he, at paragraph 22, refers to the possibility of a legal obligation of confidentiality. The appellants cannot establish a legal obligation of confidentiality owed by Her Majesty's, I beg your pardon, His Majesty's government to junior civil servants, and they have rightly never suggested they can. They have, in any event, now entirely abandoned their confidentiality argument. So the names of junior civil servants don't begin to engage the principle in Tweed and Nassay. As concerns the new argument on privacy that seemed to be advanced rather half-heartedly by the appellants, they do not claim that the Article 8 rights of junior civil servants would be breached by disclosure of their names, nor do they claim that the disclosure of names in the discharge of their duty of candour would constitute the tort of the misuse of private information. All the appellants say is that there is a reasonable expectation of privacy. But even setting aside the evidential problems that I'll come on to in a moment, if I may, a reasonable expectation of privacy is just a starting point. It's not a complete basis for establishing an Article 8 breach or the tort of misuse of private information. They don't even claim to be able to reach the next stage. And in any event, for all the reasons that we give in our skeleton argument at paragraphs 44 to 47, and by Mr. Justice Swift below at paragraph 25 below, there is no reasonable expectation, whether in confidentiality or privacy, of the names of junior civil servants. And on the contrary, of course, names are perhaps the most public information about a person, published in official registers, official documents, correspondence, and almost every social or professional encounter, on paper, online, or in real life. The appellants also argue, finally, that the disclosure of junior civil servants' names risk a chilling effect and would consequently harm government functionality. That's paragraphs 43 or 45 of the appellant's skeleton argument. 3 points about this, and I'm very conscious of time. The first point is that, as Mr. Justice Swift noted, judgment 27 below, the evidence is nowhere clear to compelling. There's no evidence of a chilling effect ever materialising. Instead, we have evidence, for example, Joanna Key's paragraph 15, supplementary bundle 92, but disclosure could have a chilling effect on government, as they might be hesitant to express concerns or provide candid advice. Nor is there real evidence of risk. Philip Keyes gives a single example of a civil servant who acted as presenting officer for the Home Office before the upper tribunal and was harassed afterwards. If anything...
You need not
yes.
dwell on that, because the logic of that would be that advocates in tribunals should be anonymised in the decisions of the tribunal and perhaps at the hearings. Speaking for myself, that wasn't a very good example, which may be why Sir James didn't rely on it.
Quite, my lord. Our second point is that the appellant's arguments and evidence about the chilling effect, such as they are, in reality relate to risks arising if the general public sees names. There's no suggestion of a problem in the respondents seeing names. The appellants have rightly never suggested that the individual respondents pose any threats to junior civil servant, or that there's any reason to believe that they would fail to comply with the rule against collateral use. Third point, the appellants seek to derogate both from a duty of candour and from open justice on the basis of chilling effect. That, in effect, is an attempt to obtain public interest immunity without a public interest immunity application. There's no other legal basis on which a purported chilling effect could justify redacting information otherwise required under the duty of candour. And that's doubly impermissible. Not only is an attempt to circumvent the strictures of the public interest immunity jurisdiction, but also because it's a request for class immunity, which of course is no longer available in public interest immunity. Fourth and final point, the Court of Appeal has an obiter dicta, but stinging terms, rejected as ridiculous the notion that public interest immunity could be granted to avert the chilling effect occasioned by the disclosure of communications between junior civil servants. They were referring to content, but the comments are equally applicable to names. So any application for public interest immunity that the appellants might make on the basis of chilling effect would be bound to fail.
Sorry,
but
what was the, you said there were obiter dicta in this
yes.
court. Can you just give us the reference?
Absolutely, my lord. It is Grosvenor Hotel. Can I ask you just
Oh, yes.
to go there? And this is my very last point. This is tab 2, authorities. Okay, the authority starts at 75. But if you could look at 124 to 125, this is Lord Justice Salmon greeting, and it's a hypothetical example he gives, greeting with incredulity the notion that there might be a chilling effect through the disclosure of routine communications. I appreciate, and this is a part way through 124, I appreciate it's of the utmost importance that the public interest and the public service should function properly. To my mind, however, it's incredible that it cannot do so unless commonplace communications between one civil servant and another are privileged from production. So, and I should, and I think the passage with which I'll leave your lordships is at the top of page 125. It seems to me that it would be an injustice to civil servants to hold that they are so timid and supine that they would not write freely and candidly unless they knew that what they wrote could in no circumstances whatsoever come to the light of day. And we would say the same applies here, replacing content with names. So, my lords, unless I can assist further, for those reasons, we invite you to dismiss the appeal.
Thank you very much, Mr. Vassalaro.
My Lords, Justice is grateful for the opportunity to make oral submissions in this appeal. We have addressed the issue of relevance and the duty of candour in our skeleton at paragraphs 23 to 26, core bundle, page 71, and I gratefully adopt the submissions of the respondents on that issue. With my very limited time, I shall be focusing exclusively on the issue of open justice. The appellants advance two main arguments in support of their contention that the redaction of JCS names is permissible. First, there is the argument on relevance, which really concerns the scope of the duty of candour. And on the back of that argument, the appellant's position is that if names do not fall within the scope of the duty of candour and do not have to be disclosed in the first place, then the open justice principle is of no application. I will address that submission quite shortly first. The second line of argument concerns other good reasons, and I will address that more fully shortly. The first argument on relevance, of course, assumes that the appellant's argument about relevance and the scope of the duty of candour succeeds. If it fails, names will have to be disclosed to claimants and the court, and they will plainly fall within the scope of the open justice principle in the normal way. In other words, the media and the public will be able to see what the court sees. See our written submissions at paragraph 12. But in considering the question of relevance, we submit in our skeleton that even if not directly engaged, some open justice principles remain important. One of the main purposes of the open justice principle is that by ensuring transparency, the courts maintain public confidence in the administration of justice. if the effect of a permissive approach to redactions were to undermine that confidence, this is a consideration that the court may properly factor into its thinking. And I respectfully adopt Mr. Binsky's submissions about the breadth of the appellant's logic extending far beyond the redaction of junior civil servants' names or indeed senior civil servants' names. In principle, it would extend to any information that is not directly relevant in the narrow way that the appellant accepts. Secondly, we submit that the court is entitled, even when considering questions of relevance and the duty of candour, to ask itself what, in bigger picture terms, such a proposal would mean for open justice. Here in this appeal, the appellants seek this court's blessing to a general practice of redacting the names of JCS in judicial review proceedings, the effect of which would be to prevent this information from entering the public domain. This information would no longer be available to the court. It could not feature in judgments. It would not become known to the public. It could not be reported by the media. It could not be studied by academics. It could not be read and analysed by anyone with a legitimate interest in understanding the way judicial review proceedings take place and the material that was before the court at the time that the court reached its decision. Yet in some cases, information may be of real importance to the media and the public, even if it is peripheral to the court's reasoning and decision-making on the facts of that case. And I will return to this point below. So while this reasoning might at first appear circular, we do submit that consistently with the divisional court's approach and Lord Justice Lewis's approach in the PCSU v Home Secretary case, which was a case about a public interest immunity application and is in the authorities bundle at 1148, paragraphs 23 to 28, the court can step back and recognise that decisions about what should be disclosed to the parties have an inevitable knock-on effect on the rights of the public as well. My lords, the main focus of my submissions is the second line of argument concerning other good reasons. And here, arguments such as the potential impact on civil servants of media publicity, the expectations of civil servants as to publicity, and the supposed chilling effect on public administration are relied on. As Mr. Binsky so eloquently submitted, it is striking that these concerns have nothing whatsoever to do with disclosure to the claimants. The concerns being expressed under this line of argument are all about provision of this information to the media and to the general public. The whole premise for these submissions is that there will be publicity of the JCS names through the media. And in our submission, in that context, it's clear that the open justice principle is engaged in the most direct way. And ordinarily, those type of concerns would be addressed by making an anonymity application. And I'll come back to that shortly, but it's never been explained in this case what it is about civil servants that make them uniquely different from every other person in this country who's coming before a court and saying, my name should be withheld from becoming public, that an ordinary anonymity application would not have to be made by them. My lords, there are some aspects of the open justice principle which I would emphasise at the outset. A fuller summary of the relevant principles can be found in section B of our written submissions, and that's in the core bundle at page 68. First, my lords, a key purpose of the principle is to enable the public to scrutinise and understand the justice process. This is vital to maintaining public confidence in the administration of justice. And my lords, from Mr. Binsky's submission, one takes the principle that public confidence is also inextricably bound up with the duty of candour, and to that extent, the duty of candour and the open justice principle go hand in hand, because the duty of candour allows the public to have confidence that litigants have the information necessary for their cases to be decided fairly. But the open justice principle allows the public and the media to see how that has happened in practice and to scrutinise and understand that process. Both elements, the duty of candour and open justice, support public confidence in the administration of justice. That principle of open justice has indeed a particular resonance and indeed importance where the courts are engaged in holding the executive to account. As Lord Judge, Lord Chief Justice said in the Binyan Mohammed case at paragraph 39, Authorities Bundle 494, in litigation between the executive in any of its manifestations and the citizen, the principle of open justice represents an element of democratic accountability and the vigorous expression of the principle of freedom of expression. Ultimately, it supports the rule of law itself. Accordingly, my lords, where the courts are engaged in deciding the lawfulness of government decisions, it is particularly important that they should do so transparently and should not be seen to be shielding any class of public servant from scrutiny or embarrassment. The practical operation of the open justice principle is, of course, an important way in which, in our democracy, information on matters of public interest enters the public domain. But what is of interest to the public and the media is not to be equated with what lawyers or judges consider important about a case. The legitimate interest of the public and media is wider than that of judges qua judges or lawyers qua lawyers, and it is not for the courts to second guess what information may be interesting or important to the media or the general public. The media is free to decide for itself what to report about a case, and the references are Lord Judge in the Binyan Mohammed case at paragraph 40, Authorities Bundle 494, Lord Neuberger in the same case at paragraph 176, page 529, and Lord Roger in the Guardian News and Media case, paragraph 68, page 467. Accordingly, we respectfully submit that this appeal should be approached on the basis that there may well be cases in future in which the names of the civil servants involved are of real interest and indeed importance to the public and the media. Indeed, the premise for the appellant's whole case on other good reasons and the concerns arising from publicity of those names is that there will indeed be such cases. It is well established that to the media, reporting the names of the persons involved in a story is very important and is part of the exercise of its editorial discretion protected by Article 10 of the European Convention on Human Rights. That's the Guardian News and Media case at paragraph 63, Authorities, page 465. Now, my lords, the names of those involved in court proceedings, whether as parties, witnesses, or indeed persons who are merely referenced in documents, is squarely within the scope of the open justice principle. And that's why ordinarily any person seeking anonymity, whether a party or a witness, or merely someone named in a document, must apply under CPR 39.24. And the ability of the court to grant relief to persons other than parties and witnesses, persons merely named in court documents, is well established. And that's the Abbasi case at paragraph 66, and the page references Authorities, page 1198. So in principle, it would be open to a civil servant referenced in a document in a judicial review, disclosed pursuant to the duty of candour, to come before the court and seek anonymity. But what they would have to do would be to meet the test set out by the CPR in Rule 39.24. And that, my lords, is in the White Book at page 1220.
I think the days of our being supplied with white books in court have long gone, Mr. Vassal Adams. So
I'm sorry.
Better just tell us.
I will simply read it out, my lord. I've given myself the wrong page reference, so that doesn't help me really. Just bear with me, please. My learned junior tells me that it's in our skeleton argument at paragraph 16.
Yes.
And it is indeed, yes.
I thought so. Would you accept on, I think paragraph 16 indicates that you probably do, that there may be cases in which redaction is justified, and it should it require the civil servant to make an anonymity application? Surely the defendant department could simply say, we have redacted this name on the grounds of national security or possibly a tangible physical threat to this individual or whatever it may be, and then the court would have to decide.
We don't accept that. We say that these two issues need to be kept distinct. One is disclosure to the claimants and to the court, and that in order to justify redaction, the defendants would have to show proper grounds for doing so, such as public interest, immunity, legal professional privilege, or one of those other established grounds, in the normal way. If the question of anonymity only arises where that information has already been provided to the claimant and the court and is in principle within the scope of open justice and part of the case. And in that context, if it's part of the case and has been disclosed to the claimant and the court, if at that stage they wish to obtain anonymity, then they are fully entitled and able to get anonymity in the ordinary way.
I suppose that the claimant is malevolent or dangerous, as some claimants are.
Well, in that case, that could in principle be a proper basis for that information being withheld from the claimant. And in those circumstances, it is unlikely that there would be any question of that information becoming public. So, but what we say you can't do, and what is in reality happening here, is to use concerns about publicity as a means of seeking to limit what information is provided to claimants, when your real concern is the publicity that arises from disclosure to the general public. And that's what's really going on here, is that concerns about publicity in terms of the general public, which would ordinarily be addressed by way of an anonymity application, which has to meet stringent tests in order to be a justifiable derogation from open justice, are being done by sleight of hand through an argument about redactions and the scope of the duty of candour. And the reason for that, my lord, is that when one looks at the test under CPR 39.2, set out at paragraph 16, the court must order that the identity of any person shall not be disclosed if and only if it considers non-disclosure necessary in order to secure the proper administration of justice and in order to protect the interests of that person. It's not just about protecting the interests of that person. It has to meet the test of being necessary in order to secure the proper administration of justice. And that test is the test laid down in Scott and Scott. It's a case of strict necessity. And the sort of circumstances that in Scott and Scott the courts envisaged meeting that would be a trade secrets case, or a case where the subject matter of the litigation would be destroyed, or there'd be real harm to the administration of justice by information becoming public, or the court hearing a case in private. They're not cases that are concerned with the private welfare of people caught up in the justice system and embarrassment and distress, and that is accepted in Scott and Scott as a necessary price to be paid for an open justice system.
But if it's not referred, if it's given to the claimant,
yes,
the name,
yes, indeed,
and if the claimant doesn't read it out in court,
yes,
you can't get it into open justice anyway without an application for the underlying evidence under Rule 4.5, whatever it is.
Yes, CPR 5.4.
Yeah.
That's right, or an application under the open justice principle at common law. But you're right. Some kind of application would need to be made for access to the underlying documentation.
Well, that's the claimant. But if the defendant says to the claimant, I'm not going to disclose this document to you because we don't think it adds anything to your case. And there are worries that this civil servant will be targeted. Say it's something like a known demonstration against a particular group or animal rights or something like that. And the claimant don't make an application for specific disclosure. Then again, you're not going to get it. I mean, open justice is parasitic, isn't it, on the information first becoming part of the evidence in the court procedure. You can't say you must make it evidence, because once it's evidence, it's open evidence.
I completely agree, my lord.
Oh, right.
I completely agree. And nothing I'm seeking to say is intended to suggest to the contrary.
Right.
I completely agree. But what we do say is that once the court has accepted that information is subject to the duty of candour and falls to be properly disclosed to the claimant and the court, that information is caught by the open justice principle to the extent that, in principle, the underlying documents can be obtained by the public, by the media, and that scrutiny can be given to the case in that way, and that if any person, whether a party or a witness or a person referenced in a document at that stage wishes to say, because there will be many cases where, and this case appears to be an example where there's no objection of disclosure of the names of the civil servants to the claimants in this case, but nonetheless the arguments about publicity are being relied on. Those are arguments that engage the open justice principle, and they must be decided by reference to principles governing open justice. And the circumstances in which a court can derogate from open justice are very limited, and they are set out, summarised in the interim non-disclosure orders guidance, my lords, which is at tab 17 of the bundle, and it's paragraphs 9 to 13 on page 576, which set out the relevant principles. And these are, of course, these principles are, of course, ones that derive primarily from the common law, but these are also principles that are now being applied in Article 8 cases as well, in terms of deciding what the appropriate test should be. And derogations from the open justice principle can only be justified in exceptional circumstances where they are strictly necessary as measures to secure the proper administration of justice. They are wholly exceptional, not a question of discretion. It's a matter of obligation. The court is under a duty either to grant the derogation or refuse it when it has applied the relevant test. There's no general exception to open justice where privacy or confidentiality is an issue. And then you can see what it says about applications being heard in private. It says anonymity will only be granted where it is strictly necessary, and then only to that extent. And the burden of establishing any derogation from the open justice principle lies on the person seeking it. It must be established by clear and cogent evidence. Now, my lords, this isn't what has happened in this case, and I'll come back to what's really happening and going on in this case. But if the evidence of Jonathan Maron, Joanna Key, and Philip Smith is assessed by reference to these principles, it wouldn't come even close to justifying a derogation from justice at common law. I want to make 3 points in relation to that evidence. I'd hope to go to it, but because of pressures of time, I'm not going to. What I would say is this. First, it's clear that the concerns relating to that evidence flow from the consequence of the media providing information to the public, not from disclosure to claimants in judicial review proceedings. In this context, it is the principle of open justice which sets the standard or the threshold at which such concerns may justify preventing disclosure to the public. See and please our written submissions at paras 16 to 18, Core Bundle 69, and 47 to 50, Core Bundle 77. Secondly, the judge was quite right to say this evidence comes nowhere close to compelling evidence, and it is a counsel of despair. judgment paragraph 28. It is wrong in principle to proceed on the basis that the media as a whole will abuse its freedom in the way in which it reports court proceedings. That's the Guardian News and Media case at paragraph 68, bundle 467. It is also wrong in principle to assume that people will react to media publicity in extreme ways and take the law into their own hands. That's the Guardian News and Media case, paragraphs 59 to 60, page 464. The evidence doesn't come close to meeting the common law test. There's no clear and cogent evidence showing why it is strictly necessary for the proper administration of justice for these names to be withheld. Possible embarrassment, distress, or reputational harm associated with public identification in court proceedings has never been a sufficient basis for a derogation from open justice from Scott and Scott over 100 years ago to the present day. The references are at paragraph 17 of our submissions, or bundle 70. Mr. Eadie, Sir James Eadie, said that here the court is really balancing on one side the ease of reading and the other side on concerns about publicity. But he missed from the analysis entirely the open justice principle, which in our respectful submission is central to the correct analysis. Finally, on this point, my lords, Article 8 is not engaged because there is no reasonable expectation of privacy, as the judge rightly found. The name and role of public servants engaged in government decision-making is not private information. Furthermore, persons occupying such roles know very well that if there is a legal challenge to a decision in which they have been involved, then their name and role may become public during those proceedings. And my Lord, Lord Justice Mayles referred to the guidance and the narrow basis on which redactions are justifiable under the guidance. In any event, as we point out at paragraphs 37 to 45 of our written submissions, a reasonable expectation of privacy, even if established, which it isn't here, wouldn't be conclusive. It's only stage one of the analysis. The court then has to carry out a balancing act between Article 8, Article 10, and open justice on the facts of the specific case. But my lords, what's really so concerning about this case? So the upshot, my lords, is that this evidence wouldn't be sufficient to get anonymity in an individual case by way of an application under CPR 39.24. But what's really concerning about this case is that the court is being asked to give its blessing to a general practice whereby the executive, in effect, grants presumptive anonymity to an entire class of public servant in judicial review proceedings. All JCS are to be granted anonymity unless their names are directly relevant in the narrow way accepted by the appellants. And what we submit is what the courts are being asked to do in reality, although not in name, is to sanction the creation of a new exception to open justice under the guise of an argument about redactions in disclosure to the claimants. It is the creation of a new exception to open justice by the back door. My lords, I'm going to give you the references rather than taking you to them now because of shortage of time. I just want to take you to one further case. But the starting point for this analysis is the case of Scott and Scott, in which the House of Lords established.
I think we do know about Scotland.
You know it very, very well, but I'm relying upon it for a principle which is not so often relied upon, which is simply for that any new exception to open justice requires primary legislation. It can only be done by Parliament. And the references are Viscount Haldane, page 26, Earl Lawbourne, page 34. I'm giving the electronic references. Lord Shaw, top of page 64, when he talks about what has happened being a usurpation. And page 72, where he talks about the policy of widening the area of secrecy is always a serious one, but it's one for Parliament. And those comments, that line of authority was picked up in the Guardian News and Media case. I'm just going to give you the page reference because of time pressures, page 456, unanimous judgment of the Supreme Court, which looked at Scott and Scott and pointed out that since Scott and Scott, all of the exceptions to open justice have been through primary legislation, and endorsed the statement of Lord Steyne in the Ries case, where Lord Steyne says there is no power in a court to create, by a process of analogy, except in the most compelling circumstances, further exceptions to the principle of open justice. And those, and that analysis was picked up in the recent case of Abbasi, which is where I'm going to conclude my submissions, and that is at page 1170 of the bundle, please. And I'd like to take my lords to it. So, my lords, this is a case which is about the family division granting reporting restrictions to prevent the naming of doctors involved in the care and treatment of children in end-of-life proceedings. And it's the judgment of Lord Burnett. It's a very recent judgment. The main issue in the case was whether, at the request of the parents, the reporting restrictions protecting the identities of those doctors should be discharged on Article 10 grounds, and the outcome was that they were. But what's interesting for present purposes is that if one looks at page 1181, please, one can see that a large number of medical organisations intervened in the case. Royal College of Nursing, British Medical Association, and so forth. And at page 1192, please, we can see their arguments set out at paragraph 44. And they essentially sought to sort the President's decision in that case to maintain the reporting restrictions. And they made a number of submissions in support of the finding that the potential impact of harassment on publicly named clinicians would be severe. And these were all made on an entirely general and generic basis. So they talked about increased public hostility towards staff involved in the care of patients who'd been involved in end-of-life proceedings, the hostility and undermining of trust between clinicians and parents, the hostility risk creating emotional and psychological distress, threatening to disrupt the quality of care, the impact on staff in the NHS and anxiety and stress and illness and so forth. So all of these factors were relied on as general reasons why these kinds of anonymity orders should be granted. And if we go to page 1208, please, you see under the heading of the judgment, the systemic and wider issues, you see the court grappling with this. And what the court says is this. This evidence was, paragraph 117, this evidence was clearly directed towards establishing a general proposition that in end-of-life cases, indefinite anonymity should be accorded to all those at least closely involved in the treatment and decision-making concerning the patient. We have already observed that the evidence of impact on health staff in this case is all generic. The effect of the decision in these cases to continue the indefinite injunctions against the world has in effect created a generic class of anonymization which endures after the end of proceedings and which is divorced from the individual circumstances of the cases or the individuals involved, just like this case. Paragraph 118, in analogous circumstances, it then refers to the Ries case and the judgment of Lord Steyne that no new exceptions to be created to open justice. And then it says, there was a need for RROs at the time, but indefinite orders would have the effect of adversely affecting open justice because they prohibit for all time an open and informed discussion of what occurred, conferring lifelong anonymity through indefinite orders, irrespective of the individual circumstances of those protected, and thereby creating a broad-ranging new class of restriction on free expression, is something which the court should do only in the most compelling circumstances. The reason is that such generic restrictions on free speech are highly controversial and should be considered in the political context by Parliament, and then give some examples of legislative action in this field. The reasoning of the House of Lords in Ries pointing to judicial restraint in creating new classes of restrictions applies here. Now, we respectfully submit the same reasoning applies in this case as well. The evidence is also wholly generic. The argument is also about the general effect of publicity on JCS. The argument is also that JCS, as a class, should not be identified in these types of proceedings. And although the court is not being asked to do it in name, it's dressed up as another argument. In reality, the court is being invited to create a new exception to open justice. My Lords, in Scott and Scott, Earl Lawburn referred to the words of Lord Justice Fletcher Moulton in the Court of Appeal, where he stated that the courts of justice, who are the guardians of public liberties, ought to be doubly vigilant against encroachments by themselves. Authorities, page 36. We respectfully invite this court, as part of its vigilance, to bring into focus the principle of open justice on this appeal.
I see that permission to appeal was given. Any news on when that might be heard?
Permission to appeal in relation to
In Abassi?
in Abassi? No, I don't have any news. I can make inquiries and see if I can provide any, and if I can, I will.
All right. Well, it's probably not going to be a timing that.
I suspect it's not going to be a timing that will work with this court, my lord.
We're not, we're not going to wait for that. Right. Thank you, Mr. Basil Adams. Sir James.
On relevance, the starting point is that there has been no case made before you by the interveners or the respondents to provide any basis on which to say that junior civil servants' names are relevant. And so the forensic approach that is taken is to swerve around that by redefining the concept of relevance, so that it now becomes a concept which is said to include direct and therefore presumably indirect relevance. And my learned friend Mr. Basil Adams accused me of defining relevance in what he described as a narrow way. My submission is that relevance is a clear and accepted concept across all of the case law that you have seen. All of that case law indicates that relevance is to be determined by reference to the issues in the case. It's not a question of saying, well, what's the degree of connection? It's got to be something which assists the court to determine the issues, rather than simply something which is generally descriptive of what might have gone on around the edges but doesn't bear any relation to and will not assist the court to determine the issues. So my submission is that relevance is a clearly understood concept. Now, of course, there are various ways in which that concept, related as it is to the determination of the issues by the court, can be described. That was in essence what was being explored in the Shah decision, where the choice that the members of the court had a little difficulty with amongst themselves was whether or not the description that was given by Lord Bingham, some form of litigious advantage, was or was not a good or useful description in circumstances in which the CPR had described that concept in a different way and the thing had become codified. But none of that touches the basic and core definition of relevance, which is something which does actually bear in a material way on the resolution of the issues that the court has to determine. I also took you to authority, and there doesn't appear to be any real dispute about this. I took you to authority which made it clear that the duty of candour in judicial review proceedings is itself bounded by relevance. And by that I mean bounded by relevance in accordance with its well-established, well-understood meaning. It is not a concept which includes everything to do with the process, irrespective of whether the process is an issue or not, including the names of anyone involved in any part of the decision-making at any point. Relevance goes to the material which bears on the determination of the issues. That is why all of the authorities to which I took you in opening, a succession of them, in the Court of Appeal and in the Supreme Court, define the relevance issue in that way. So you have in particular paragraph 50 of Quark, which my learned friend Mr. Vinsky sought to finesse by saying, well, it's all about the sentence that refers to a true and comprehensive account, whatever the phraseology is. I'm not going to go back to it. But the fact of the matter is that paragraph 50 in Lord Justice Lawes' judgment makes it absolutely clear, because it says so in terms that what he is actually talking about in terms of that account is an account which is relevant to the issue. He uses that phrase, and he uses it unsurprisingly. Why those words are used in Lord Justice Laws's approach, if not to indicate relevance in the sense that I have described, is a matter which is not addressed in the submissions at all. But all of the case law, I don't go back through it, that I took you to, from Lady Hale in Bonku to Lord Justice Singh in Bonku, recited and repeated, but in the Good Law Project case, all of that refers to issues, issues, issues. It's related to the issues. And so the citation from Mr. Justice Fordham, even if of real interest at this level, doesn't do anything different. The fact of the matter is that in tab 42, page 1272, at subparagraph 5, which my learned friend took you to, but also at subparagraph 3, all he does is to recite and re-recite Lord Justice Laws in paragraph 50 of court fishing, matters which are relevant to the issue. So that's the first point I make about relevance, and I don't go back over all the authority, but there was nothing to gainsay that apart from an attempt to redefine it. But Ms. Dubinsky said, well, the duty of candour includes an appearance, and includes the appearances that the public may get from effectively any form of redaction, appeared to be the submission. And she referred to Mr. Justice Girvan in the Court of Northern Ireland in the Downs case at tab 11. She referred to his reference there to what might be deeply damaging. Paragraph 21 was the paragraph. And I do just want to go back very briefly to that to show you what was in fact being said by Mr. Justice Girvan. Tab 11 of Authorities Bundle 1, page 364, at paragraph 21. What was said to have the potential to engender cynicism, I'm taking the words from about 7 or 8 or perhaps even 10 lines into the paragraph 21 on page 364, what was said to have the potential to engender cynicism or lack of trust and be deeply damaging was what was referred to in the previous sentence. If the executive were free to cover up or withhold material or present it in a partial or partisan way, the citizen's proper recourse to the court and his right to a fair hearing would be frustrated. Such a practice would engender. So what he's talking about is a breach of the duty of candour, which requires a full, frank and fair explanation of the facts. He is not saying, as appeared to be the implication, that every time you redact anything, the public has a justified ground for feeling that might be deeply damaging and worrying about the appearances and the effect on the appearance of justice, which of course everyone accepts as an important principle. So one needs to be very, very careful about taking those sorts of statements and then implying or submitting that they actually apply whenever anything is redacted. They don't. They apply to a breach of the duty of candour. And we would accept that the conduct he describes in that paragraph would be the clearest possible breach of the duty of candour. There is, by contrast, we submit, as I submitted in opening and I repeat in reply, no difficulty with the appearance of the court doing justice and the government cooperating in a proper way with its duty of candour to provide a full and frank explanation of the facts, if what is redacted is irrelevant in the sense that I have indicated. In other words, is material which bears no relation and will not assist the court in the determination of the issues. So really the thrust of the case, as it ultimately came down from Ms. Dubinsky, was her agreement with my Lord Justice Lewis that relevance for the purposes of judicial review is to be treated as including in all cases the process by which the decision is reached. And in relation to that, I submit, first of all, that of course it is the case that the process by which a decision is reached may form an actual pleaded or a potential arguable ground for judicial review. And if and to the extent that it does raise a concern, or there is a pleaded case of that description, then a full and frank description of that process, likely to be principally in a witness statement explaining what the process looked like and how it was gone through in a full, frank and proper way, but potentially supported by the end documents in the decision making, like the final relevant ministerial submission, will be produced. So there may be a question in a judicial review which engages that process, but it won't be every case. There may well be cases, a vast run of cases, in which what is attacked is the substance of the decision. For example, the proportionality of the decision, and whether or not the end result is a matter which is sustainable as compatible with, for example, the European Convention on Human Rights in the form of any of the qualified rights or in the form of a discrimination claim.
In fairness, I understood Ms. Dubinsky to give two answers. One, she agreed with the suggestion that relevance on one reading requirement includes the decision-making process. But I've also got a note saying that separately, the need for significance, context, intelligibility are part of relevance, actually, that achieving those things are themselves part of the issue or part of the relevant matter that needs to be addressed. Maybe a different way of putting the same part.
My Lord, I suspect it's probably a different way of putting the same thing. The question is, do you have to, or is it always relevant to describe the process? It may be. But as I say, the obvious ground on which, or the obvious basis on which that would be relevant is if there is an actual challenge to the process itself, which there perfectly obviously can be, and quite often is in judicial reviews. But there isn't a general proposition that it is always necessary or relevant even to go there. If there is no difficulty with the process by which the decision is reached, you focus on the nature of the issues, actual and potential, in the proceedings, and they may well only involve a challenge to the substance of the decision. But even in a case, is the second submission, even in a case in which there may be a question, a ground, a potential ground that goes to the process by which the decision is made, that fact does not make relevant in any sense, or any real material sense, the identity of everyone involved in the discussion of the issues that form part of that process. It does not render relevant, even in the broadest sense, everyone who was ever part of an email chain comprising 15 people to whom something is sent.
No, but I think your submission is broader than that, Sir James. You're saying, save in rare cases where there's allegation of personal corruption or conflict of interest or something of that case, the identity of anybody taking part other than the minister is irrelevant.
Well, I don't have to go that far. I accept that is the logic in principle of the position.
Yeah.
But I do not have to go that far. I don't have to go that far because in practice, as you know, senior civil servants are named. And in practice, ministers and secretaries of state, of course, obviously are too. And so there's no difficulty with that. And moreover, I think as we've accepted in the skeleton argument, it is, of course, possible to take a broader position even than that. It is possible, and you saw Mrs. Justice O'Farrell do it in the Good Law Project case. She said, well, if the person is the actual decision maker, there may be a different set of arguments as to whether or not that should be included. And if and to the extent, even if they were junior civil servants, that they were involved in a particularly important part of it and so on. So there may be questions of degree involved in relation to that. And I'm perfectly prepared to accept all of those for the purpose of this argument, because what is being said, I mean, it can perfectly fairly be put to me that that's the logic of my position, but the logic of the other side's position is entirely the other way, entirely open-ended. Thou must always, as long only as it features in the sort of email chains that we've seen. I should say in relation to that, were they the decision-maker matter, we looked again at the paragraph that my Lord referred to, and I confess it's difficult to know precisely what is being said and what the scope of that paragraph 11 is in Miss Key's statement, I don't think it can properly be read or taken as indicating an assertion of a factual position across the entire civil service. As I indicated, I mean, there may be questions or debates which we don't know the answer to about whether or not people are regarded as civil servants or office holders or whatever it may be in the immigration context, but I'm entirely prepared to accept that there will be a range of junior civil servants who, particularly perhaps in the immigration context, will in fact make decisions.
Whereas detention as well, next week we've got a case on detention where there have been 8 or 10 reviews of detention,
Yes.
and then there's a prison officer and there's a review by a more senior officer, and they're not.
My lord, yes, so I'm certainly not advancing that as it were a full-blown position across the civil servant that only SCS ever make decisions. Of course that wouldn't be right. And I suspect that what she truly had in mind, if I'm allowed to say this, that what she truly had in mind, I suspect, was policy decisions of this type in levelling up. And fair enough in relation to that, but I'm certainly not pushing the extremity of that evidence as evidence.
Does it matter that the situation here is this? You could have satisfied what are really the expectations of candour, we call it the duty of candour, by making a witness statement to address the grounds and explain what happened, or by documents, or both. You voluntarily chose to tell the claimants in the court what happened by voluntarily providing documents. And if you do that, then unless you've got a good reason, you shouldn't start saying, well, I'm going to tell you a bit, I'll show the ankle, but not the thigh, or the calf, or something. Does it matter that you started your duty of candour by saying, right, the way I'm going to meet this is by providing documents? But, without good reason on this hypothesis, not all the documents.
My lord, in principle, I respectfully submit that tends to obscure rather than elucidate the issues. I'm told that there was also evidence provided, and of course one can take a position which is more or less strict as to the division between those two mechanisms of satisfying the duty of candour. And very often a description of the process in broad terms will be provided in a witness statement, and then a selection will be made about what documents to append. And very often they will be restricted to the critical documents that inform the final decision making. Certainly if that's made by ministers and secretaries of state, my lord will need no lectures from me about how that works, but normally you produce the final one, and because that would be the principal basis on which the decision was reasoned, and ultimately everything that happened, all the discussions, all the whizzing around the room and blue sky thinking and all the other things that happen within the
Wouldn't
civil
be there
service.
at all, actually. You might not have needed to have provided that information to discharge your duty of candour, but once you have done that.
But if we have done that, so be it. I mean, my respectful submission, that doesn't make or break the point about junior civil servants. I mean, the real question, I suppose, and the third submission I make here, is in answer to the question, to the point that is made, which is that redaction of names will obscure, of the junior civil service names, will obscure the significance of the document, or in some way not give you the proper context to that decision-making, brackets, even though it doesn't assist the court to determine the issues. And my answer even to that way of putting it, that low-level way of putting it, in other words, to accept that it doesn't, as they do, inform the actual determination of the actual issues, and then to say, but there's a broader principle, which is you need to look at the process more generally because it's a JR, and then you say it will obscure the significance or the context. But the question that prompts is, why will it do so? You are not selecting in a harmful way of the kind envisaged by Mr. and Mrs. Girvan how you present that. Indeed, it's entirely clear from the redactions that the only thing that has actually gone is the name Smith from a bunch of people who were included in providing documents to the Secretary of State's office or discussing matters or whizzing documents around in email chains. And so we respectfully submit that goes nowhere. The only example Melanie Femis-Dubinsky was able to give was to say, well, you could have a hypothetical example in which there is in internal documentation criticism of the policy. Well, frankly, criticism of the policy is no more relevant to the court's determination of anything than praise of the policy would be. Otherwise, there would be lots of emails sent praising the wonders and proportionality and compatibility of the policy. But it's no more relevant or interesting for the court to see that form of criticism. There may, of course, be separate issues in relation to CCR and the offering of political opinions. CCR being collective cabinet responsibility. But so far as that example is concerned, it goes nowhere. And if that's the best hypothetical example that can be come up with for why the redaction of names, which will not assist the determination of the issues, might be considered to be relevant, then we are down among the dead men in terms of justification for that. And the chain and the redactions will in any event show that the only things redacted, as per all of the documents you've seen, are the names of the junior civil servants. So even if something is critical, then, or there is a margined criticism of the policy, even assuming that's remotely interesting, you will know that it has come from that source for what that is worth. So we do respectively submit that the justification for the production of all of this is not made out, and we are very, very concerned on this side of the court that you are being invited fundamentally to re-describe and redefine the duty of candour so that it always includes some form of, quote, comprehensive account of the decision-making process, even in a case in which there is no question of a ground arising in relation to that decision-making process. And we submit that you can posit, as I have done, a whole series of examples where all that is remotely capable of being challenged is the substance of the decision. That's why we say there has to be a link between the disclosure and the issues in the court, and the issues that the court will ultimately have to decide. So we do respectfully submit that that is a difficult part of the case for my learned friend. So far as Tweed is concerned, when I was making my submissions, I think my Lord Justice Bean queried whether the claimant was actually saying that you cannot redact at all for irrelevance. And although this case is, of course, and only about junior civil service names, my learned friend is, it appears from her oral submissions, indeed making the submission that you cannot redact at all for irrelevance. And my answer to that, if you were even remotely tempted to even consider that issue in this case, is that that simply cannot be right.
Well, we're only concerned with the issue of redaction of names. You, Sir James, with respect, in the last 10 minutes have suggested that we might offer broad philosophical guidance on relevance and so on, but we are only concerned with the issue of redaction of names. It's an important issue, but we're not disposed to go further than that either way.
My Lord, I'm grateful. Then I won't make the submissions I would have made about the redaction of content on irrelevance grounds, which would have been pretty obvious anyway. The more substantial point, I suspect, in relation to Tweed, is that Tweed was not espousing a principle of irrelevance not being a ground for refusing disclosure. Obviously, that is an important principle for the purpose of junior civil servants' names, because it's the primary basis on which we justify the redaction. And the reason I say it is not that principle casting it in the negative, is to meet the submission that was being made that it was really all about confidentiality. The fact of the matter is that Lord Bingham went out of his way, and it's become the mantra, to define in the context of disclosure of documents what the test actually was. And the test is the one in the final sentence of paragraph 3. Is it necessary for the purpose of resolving, underlined, the matter? And the matter means resolving the issues in the case. Back to my definition of relevance. So we place positive reliance on that for that purpose. So far as intelligibility is concerned, the highest my learned friend Mr. Binsky was able to put it was to say that the cumulative effect of all of this, including the redactions of content with which you're not concerned, was, quote, not insignificant. So far as intelligibility is concerned, my submission, as you know, is that the test in judicial review is, as it was in and is in ordinary civil proceedings, and the duty of candour does not touch this, the one set out by Lord Hoffman in GE Capital, not misleading and not destructive of the sense of the document. and the names by definition can't do either of those things, which is to their advantage in this sphere, because it's the content that truly matters in a judicial review, as no doubt it does in ordinary civil proceedings. You have to test the intelligibility question, as I indicated in opening and in answer to my learned friend's submissions. You have to test that by reference to the significance or the contribution to greater intelligibility simply of the actual names. And the reason I put it that way is because that's the issue of principle, and there is the possibility of ciphering. We've had all sorts of debates around the procedure to do with that. But once one takes into account ciphering, if there is a reason for doing that, and there may very well not be in most of these cases, but if there is a reason for doing it, it can be done. And what that does is to find this down. Why is it that Smith is significant, is the question I continue to pose and that has not been answered in my learned friend's submissions. The documents that you have seen, I respectfully submit, are not rendered difficult to follow or to understand because the name Smith and other names have been redacted. The content isn't touched. It will sit alongside the statement of facts that is in whatever evidence is provided, and there is no suggestion that the name of the junior civil servant, for example, who sent the ministerial submission to the Secretary of State's private office on page 223, is of any interest whatever to anyone. The fact of the matter is, a particular submission with a particular content went to the Secretary of State. The amanuensis for that is neither here nor there. Finally and briefly in relation to balance, if I may, my submission is that it is not necessary in the context of a judicial review under the duty of candour, if that's the way the argument is being put, which it is not necessary to identify some form of enforceable legal right before material of this kind can be redacted. The concept of the public interest is, on any view, considerably broader than that. And it is the concept of public interest which matters. Grosvenor, which my learned friend Mr. Vassell-Adams relied upon, I think at tab 2, is about the application of an absolute rule of Crown privilege, as it was in those days. And of course, that does not establish that there is no interest in the protection of the names of junior civil servants, and there aren't real concerns around the disclosure of those names, which would need to be balanced in any consideration of whether it's appropriate to do so. Indeed, the fact that that is so is evident not merely from the content of the Freedom of Information Act, including in particular the provisions which protect the revelation of their names, including, no doubt, section 35, section 40, sub 2, but you also have the decision of the upper tribunal considering at least some of those very issues in the context of the Cox case, on which no real submissions in reply were advanced orally by my learned friends. So we do respectfully submit that Grosvenor doesn't assist. The key point, perhaps, in relation to the balance is that no one, neither my learned friend Mr. Vassell-Adams nor my learned friend Ms. Dubinsky, really had anything to say about my description of the core premise to the public interest issues in disclosure of junior civil servants' names. In other words, that the premise is that those names and their disclosure would be irrelevant to the court's determination of the issues, and so the premise is that the maximum public interest that can possibly be derived has to take that fact into account, A, but also B, can go no further than an aid to assisting intelligibility justification. There is no real or material deficit to the open justice principle on that basis. And we respectfully submit that you should so decide. Of course, we accept in principle that there may be a distinction in some cases between disclosure to a claimant and disclosure to the public. that is self-evident from the fact that you sometimes have confidentiality rings where the litigants or some part of their legal team can see things and the press, for example, cannot. But we do not accept Mr. Vassell-Adams' follow-up punch, which is so we don't have to worry about any of the former here, in other words, disclosure to claimants. The justification for being concerned about the revelation of junior civil servants' names includes the possibility that they will end up having to field, as it were, a bunch of difficult comments on social media, including inter alia or perhaps even in particular from claimants who are the subject of decisions that they don't like, or those to whom they are the people who are concerned with those issues. So that then took the debate into, well, can you be protected? Because, as Lord Justice Lewis said entirely rightly, and my lady friend accepted it, it doesn't go out into the public domain unless someone's read it in open court. It doesn't hit the evidential record till you get to that point. That's obviously right. The difficulty with that is that it provides no protection. It doesn't give one any proper protection, which is why, in this case, the order said that what it did in relation to confidentiality rings, because it is no real comfort that the protection of junior civil servants' names and the concerns about revealing those to the world depend only on whether or not the claimant or their lawyers choose to refer to those names in open court. The protection, if it deserves protection, is a protection that the law should provide, that should not depend upon the adventitious fact, and it may be the cynical fact in some cases, although of course not in this case, of whether or not the claimant chooses to put those names into the public domain. So the protection, if it deserves it, as I say, deserves to be properly protected by the law. The final point I wish to make, and sorry if I haven't gone a little bit over, but the final point I wanted to make was about the final flourish of Mr. Vassell-Adams and the Abbasi case. It might be thought that that case illustrates, if any case ever did, the usual and expected caution which courts will exercise in jumping from one set of issues in a very particular context to seek to derive general principles or a general approach. Abbasi, it might be thought, is a paradigm example of a special set of issues arising in a particularly fraught and very special context with a special set and a very particular set of public interests associated with it. We, of course, are dealing with something different, and so we urge considerable caution before seeking to draw general principles from that Court of Appeal decision, even if it survives the tender ministrations of the Supreme Court, assuming permission to appeal is granted. And also, those are my submissions in reply, unless I can seek to assist further.
Thank you very much, Sir James, and all of you. We will retire for a short time and see whether we can give you a result today, so that when the 7th of February hearing occurs, know how to approach it. If anybody, particularly Sir James, in my experience, often has conferences post-court with people of great importance. If should that be the case and you wish to retire from court, that will be entirely acceptable, but otherwise we will return as soon as we can.
Well done. It was slightly disturbing if I was flicking through the judges. It was slightly distracting in general, in terms of totally useless. Yeah.
One-page judgment.
It's difficult to sell to a layman.
Yeah.
Oh, that's very interesting. That killer way.
Just give me 1 second. I'm going to give you just a little bit more to take with you. Brilliant. Thank you. You can have that now. This is a lifesaver. You can't charge max. It's called unredacted.
I'm the king. Yeah, exactly. You've got to do it.
I'm so sorry, I hope it's not dog eared.
Some the precedent, the most senior judges, when they're talking in plenary, and some have the opposite, which is the most junior judges. And I'm having the impression that you've been appointed last week.
I think that everyone's like, no, I disagree.
Right, exactly. So tell your views on some cases absolutely outside any area of school.
Yeah.
How about it?
They also know exactly what the answer is.
The live stream is still on, so just to let you know. Okay. No, it's up to you. You can.
That was me.
Exactly what it's
We're all thinking. Yeah, fine.
I feel like I don't know, maybe not. It can be only women.
That's DBS.
Yes.
And then Wednesday you guys put that one. Might not be Wednesday.
We could have found a 5 to extend it.
Sorry? Yeah. Young Tom's there.
Oh my gosh,
You can't be that far away.
we've been here for 11 plus. So I've been juggling this, the underlying challenge.
It had a really detrimental impact on his self-confidence. The whole process was documented.
Awful. I mean, and I don't, I mean, I just, I have no idea.
Well, this, the one that
It's some of the same resilience for me to have gone through this agony. But I'm really not sure it's really just I completely understand it. She's coming in post for an interview and crash, and I'm just worrying about how much I do.
Well, there is a really lovely unselected school.
That's the way
That's where Tom is.
Yeah, I know actually really regret a whole host of things, including not just having stayed in the States to avoid all this. Schools are now
Where would you be in your catchment if you were sitting?
We have all decided that the appeal from Mr. Justice Swift's order should be dismissed. We will give reasons for that decision in the usual way in due course. Are there any consequential matters to be dealt with today? It seems to us that the stay imposed by paragraph 2 of the order which was handed up this morning it is now discharged.
My Lord, there may be questions of whether or not my instructions are to seek permission to go higher. It's impossible for me to take any position on that until I see the reasons that the court gives for the decision that you kindly announced just now. There may, if there is an application, or unless and until these proceedings finally conclude, the preemption issues which underpin that paragraph of the order would remain. So my submission would be that that order should not come to an end immediately, and that the position should remain at least until the Supreme Court have offered a view on permission. For the time being, the position in relation to the trial at least is protected because the claimants' lawyers can see what lies behind the redactions, and it may be that the issue will drop away entirely if no reference is made to anything in open court. But unless and until that position happens, as I say, the underpinning of that order, which was preemption of live issues of principle, will remain. And so my submission would be that that order should remain. No doubt it can be the subject of submissions, written or otherwise, as to consequentials when and if we see, or when we see, the reasons that the court has given.
Should it be the other way around? We have now got to open justice scenario 2. We've said that the redactions in the evidence that you put in shouldn't be there. If you want further protection, you do need to get directions and orders under 54C or 45C, whichever it is, and or anonymity, and you should do that before the administrative court.
Well, my lord, that is part of the nature of the issues that you will no doubt be providing reasons about. It's difficult, I respectfully submit, to get to that stage in advance of seeing what your reasoning is actually going to be. And until that happens, I can't take a position on permission to appeal because I don't know what you're going to say.
No, I understand about the permission to appeal. It's about the protection of the information in the administrative court hearing in 3 weeks' time or whatever it is. Because they've got it, so they don't need to worry about it. The question is whether they put something in their skeleton argument or whether a member of the press goes and asks the administrative court office for copies of it.
But there will be live issues on that basis, unless and until the issues of principle have been determined. Because if I'm right, ultimately, on relevance, let's assume, and no doubt what my lord would regard as a deeply unlikely event, the Supreme Court grant permission and then decide in my favour, the horse will have bolted from the stable. That's what I mean by the preemption issue. It can't be the position that the position is, as it were, altered the other way, so that a further application has to be made to the High Court.
If it's protection of individuals, you can still protect individuals. What you can't do is protect your position. That it's up to you really to decide whether or not to disclose it because of the definition of relevance. But I get the point.
My lord, yes, but in the end, that will be a live issue for the Supreme Court. And if the Supreme Court accept my submissions, as you know, the position will be that they don't have to be disclosed because they are irrelevant. And at that point, if the matter has been revealed in trial, referred to in the skeleton argument, absent any application, there's not much point in making an application to Mr. Justice Swift. That order, he's already ruled, and he'll not make
I suppose another way of looking at it is that the stay which was imposed could continue because it is it's only a partial stay, and it says that the unredacted documents must not be referred to, read out, or otherwise disclosed in open court without agreement of the defendants or the permission of the court. And if we leave that order undisturbed, then it would be open to Ms. Dubinsky at the substantive hearing to say to the judge, we want to read out the whole of what's on page whatever, or mention this name, and then it would be for the judge to rule.
I guess that would achieve the same effect. It's already built into the order.
Yes.
And if a reason for that is given, then it may be that that would show that there was, after all, some relevance, in your sense, in the name.
My lord, possibly. We'd have to see we'd have to see what the reason was.
You may not be
the best person to
involved in the actual trial of the judicial review. But
there's no mayor about it.
But I mean, it might. Those who are going to be might have a view about whether the existing regime is in fact practicable to work under.
Well, my lord, there may be lots of issues that need to be determined, but my submission is that the suggestion from my Lord Justice Bean is an appropriate and sensible one. Rely on the terms of the order.
Mr. Binsky?
No objections, my lord.
Very good. Then the order will simply be that the appeal is dismissed for reasons which we shall give in due course.
Well, I should flag as well that we're still having a look at what the effect of that might be. But at the moment, as I understand it, there's nothing we can invite you to do in relation to the time period or the time periods within which applications have to be made for permission to appeal to the Supreme Court, which I think are 28 days from order or something else, order or decision. But it may well be that in this situation, given the obvious logic of the fact that we can't actually make a decision about permission to appeal until we see the reasons, the Supreme Court might be a bit forgiving, but we don't at the moment think that there is anything that you can do.
I think you've actually got to apply to the Supreme Court for an extension of time.
I think we probably do, and I don't think there's any power that you have.
I don't think we have. We've gone through this in a new number of cases.
Good.
We just
It
can't.
may be that since we're dismissing the appeal, even that order doesn't have to be drawn up until we give reasons. It would be otherwise if we were allowing the appeal and interfering.
Yes, my lord, I'm not sure that's going to save us because it's order
So it's
or
the announcement
it's
of the
order or
decision.
decision.
Right. We will simply the order will be that the appeal will be dismissed, and if we take so long over the reasons that you run out of time, you can no doubt make an application to the Supreme Court.
Thank you for that.
Anything else to be dealt with today? Thank you all very much for your assistance.